Hello everybody, my name is Sharon. I'm an employment lawyer and I'm here today to talk to you about the legal implications of social media from an HR perspective. Social media has arguably become the most influential channel of communication in today's very connected world. Employees use it widely in a personal capacity, and employers have discovered that they can harness it very effectively to promote their brand and get their message out in new and innovative ways. Things have developed to the point where it is now imperative for most businesses to have some form of social media presence. The difficulty is that although social media can be an enormous asset to an organisation, it also has the potential to cause extensive damage to a business's reputation, brand and value within a matter of minutes. Many businesses want to be able to encourage employees to use the opportunities that social media offers, but the need for active engagement on an individual level means that the employer is obliged to place an unprecedented degree of trust in employees, possibly at all levels throughout the organisation. How do you strike a balance between encouraging your employees to be creative and to express themselves, whilst exerting a sufficient degree of control over their online behaviour? This has become a business-critical risk management issue. Not just business risk, but legal risk too. Social media can expose employers to all sorts of legal risks: loss of confidential information, bullying and harassment claims, data protection issues. The list goes on. We have all read about horror stories in the press, such as the one involving the employee of a global PR company who made a racist tweet as she was boarding an aeroplane. The world of Twitter reacted with fury, and by the time she landed it had gone viral, doubtless leaving her HR department with a mess on their hands. Clearly, by the time things have reached that stage, you will find yourself reaching for the good old disciplinary policy and the ACAS code of practice. In sufficiently serious cases, you might even find yourself wondering whether the employee's conduct has been so bad that you are entitled to dismiss summarily without notice or payment in lieu of notice. The employment tribunals are starting to see a trickle of cases involving dismissals that were caused by social media blunders. An important part of our job as HR professionals and employment lawyers is, of course, to ensure that any dismissals are handled in a legally compliant manner. That means ensuring that any dismissals are fair and that they can be defended at tribunals should the need arise. In an ideal world, you want to manage things in such a way that you don't ever find yourself in an employment tribunal arguing about whether the dismissal was or wasn't fair. But life doesn't always work like that. And if you do find yourself facing a tribunal, you are going to find that you will have a very much harder time persuading them that you acted lawfully if you haven't thought about social media and implemented an effective social media strategy in advance. Proper management of the legal risk requires you to get out in front of the problem before it occurs. If you take that approach, you are much more likely to be able to lawfully discipline and dismiss an errant employee when the situation arises without the risk of litigation. Adopting a proactive social media strategy not only helps you to manage the legal risk, it also helps you as HR professionals to add strategic value with a view to helping senior management to maximise the upside whilst minimising the downside risk to the business. Nobody wants to be on the receiving end of a call from a journalist asking for a comment on a story they are going to run about a gaffe one of your employees has made on social media. Nor do you want to find out from Twitter that one of your employees has caused enormous reputational damage to the organisation. This is a case where prevention is very much better than cure. So how do you as HR professionals achieve this? How do you ensure that your employees stay on message in a way that promotes your values and your brand in the fast-moving online world of social media? In this new world, the level of dynamism and speed is so high that it is impossible to control behaviour with policies alone. Policies and other employment documents do remain part of the picture, of course, and they will form part of any well-thought-through social media strategy. Without those, you are likely to find yourself facing an uphill struggle from a legal perspective. But in order to properly grapple with the challenges that new media presents, we don't just need a new version of your employee handbook, we need a new vision. We need new models for compliance, which are scalable and melded with the overall marketing strategy for the organisation. HR social media policy should be an enabler for brand enhancement, not an Orwellian attempt to apply old-world solutions to new-world problems. You can achieve that while simultaneously protecting your organisation as best you can from a legal perspective. I'm going to suggest that you consider a three-step strategy, a strategy that you can take to your business leaders that shows you are aware of the legal as well as the business risks and that you have come up with a solution to address them. The three steps are prepare, scale and monitor. The first step, prepare, involves determining what your organisational stance on social media is going to be and what best practice and compliance look like for you. This is where your policies and procedures do come into the equation. The most relevant documents you will want to review will be your contracts of employment, which will need to be properly drafted, and your disciplinary policy, which ought to dovetail with your contracts. And of course, your social media policy. Your social media policy ought to cover permitted use of social media. When do employees have authority to speak on behalf of the company, for example? What about personal use that might lead to an employee being regarded, perhaps inadvertently, as an unofficial spokesperson for the company? Clear guidelines ought to be given about how confidential information ought to be handled, when employees can comment on public announcements about the company, and how confrontational they are allowed to be in online posts that might be attributed to the company. Importantly, it also ought to deal with when they can be disciplined for inappropriate use of social media. Having these documents in place will be important if and when you ever have to deal with a disciplinary or a dismissal situation. To make them as effective as possible, they should ideally be created with input from not only HR and legal, but also your marketing team and your business leaders. Taking that approach will give you confidence that your documentation captures and addresses the concerns that are specific to your organisation. But real-world compliance goes beyond that, because the reality is that many employees will not read all of the beautiful documents that have been drafted by HR and by employment lawyers, at least not until after the damage has been done. That means you need to go further, which brings me to the second step, which is scale. Employees need to understand not only what tools they are permitted to use, but also what the organisation's values are and how it wants to be perceived in the marketplace. This step is critically important from a legal perspective, because if you do find yourself in a situation where you want to discipline or dismiss an employee who has crossed the line, an employment tribunal will expect you to be able to demonstrate that the employee clearly understood what was and what was not considered to be acceptable behaviour. We do live in a world of new media, but it is worth remembering that the legal principles remain the same. That means if you find yourself facing a claim of unfair dismissal when you have dismissed an employee for online behaviour, the Employment Tribunal will apply the same test it did before the advent of social media. It will assess whether you acted as a reasonable employer would have done in all of the circumstances. It will therefore fall to you as the employer to explain why the action you took was fair and reasonable. And in considering whether to find in your favour, the tribunal will expect you to produce evidence that you clearly communicated to employees where the lines were drawn. If you fail to take that vital step, you are likely to find the tribunal will consider that the dismissal was unfair. If you haven't told employees in clear terms what is allowed and what is not, how are they supposed to know what they can and can't do? This means that you need to create awareness amongst your workforce. In the days when employers only had to worry about old media, it would have been unthinkable for an employee to be allowed to speak on behalf of the company, on television for example, without some form of media training. Most large organisations tend to have a high level of maturity when they are required to engage with old media. Why should the approach be any different when new media is involved? If anything, the risks are greater. The solution to this is for your organisation to be proactive in its handling of this. This requires you to train employees in what is regarded as best practice for your organisation. A formal social media training programme gives employers an opportunity to educate employees about marketing or branding guidelines, and it allows organisational boundaries to be set and communicated. Now, you might have the time and resources to train employees on an individual basis, but if you don't, one solution that you might want to consider is the creation of a network of social media champions within your organisation. Champions are individuals who have either received formal training or who have shown themselves to be trusted and effective users of social media. Encouraging new joiners to follow these champions enables them to learn by example. Even if you do roll out individual training, you won't be able to cover every eventuality, so employees will find it much more useful if they can observe practical, real-life examples of what is right and wrong. Employees generally welcome this sort of guidance. It means that they are given the freedom and flexibility to contribute positively towards enhancing the brand and reputation of the company, secure in the knowledge that their careers will not be at risk provided they do not stray beyond the clearly marked boundaries. The third and final step involves monitoring. How do you keep abreast of your employees' online activity so you can detect potential issues and reduce the risk of large-scale problems materialising? One solution that a number of big companies are investing in is the creation of social media command centres. Companies such as Dell are using this technology to monitor what customers are saying about their brand. Why not extend this to cover what employees are saying on social media and then react accordingly? However you decide to monitor your employees' social media activities, it is important from a legal perspective not to overlook the potential data protection implications of such monitoring. As a minimum, employees ought to be informed at the outset that you are intending to monitor their online activity in this way. So in summary, investing the time in the creation and rollout of a well thought out and well documented approach to social and new media positions an organisation well for success. Despite the best intentions of employees, things can quickly turn sour. But by taking a strategic and proactive approach to this issue, you can help your organisation to manage the business and the legal risks and ensure it is prepared and hopefully ahead of the curve in the event that a social media incident arises. I hope that this three-step strategy I have suggested of prepare, scale and monitor will help you to achieve this.